GDPR says that certain data processing activities are so risky that they require an additional level of evaluation before an organization can move forward in compliance. That additional level of evaluation is called a Data Protection Impact Assessment, or DPIA for short. A Data Protection Impact Assessment is a privacy-based risk assessment for a particular data processing activity that's under consideration. Organizations that are required to undergo DPIAs are responsible for evaluating the risks to the rights and freedoms of individuals, identifying any controls that could reduce the privacy risk to those individuals, and determining whether or not the risk can be reduced enough to move forward without threatening data subjects unreasonably. There are a couple of different ways that an organization can determine whether or not it needs to undergo a DPIA. Some countries have what's called blacklists and whitelists. Those are lists of activities that require data protection impact assessment, most frequently when it involves AI, biometric information, or facial recognition software, as well as wearables. Those are a few examples of data processing activities that require a DPIA. There are other lists where European data authorities have determined certain activities are safe enough that they don't require a data protection impact assessment ever. Another way that an organization might determine that it needs to perform a DPIA is simply to ask a data protection authority whether or not it needs to complete a DPIA, and then allow that data protection authority to provide feedback and guidance. For any DPIA, the data protection officer should be involved, it should be documented, and it should meet the standards set forth in GDPR. And those records should be maintained to provide to supervisory authorities upon request.